Hello learners, welcome back to your educational channel Learn and Educate. Civil Procedure Code considers and amends the law relating to the procedure of the courts of civil nature. In the last video we have learned about section 88 and now we will study section 89 part 5 special proceedings arbitration. Section 89 Settlement of disputes outside the court. Subsection 1 Where it appears to the court that there still exists an element of a settlement which may be acceptable to the parties, the court shall formulate the terms of the settlement and give them to the parties for their observations, and after receiving the observations of the parties, the court may formulate the terms of a possible settlement and refer it the same for A. Arbitration, B. Conciliation, C. Judicial settlement including settlement through Lok Adalat, or D. Mediation. When it appears to the court that there is still an element of settlement which shall be acceptable to both the parties, to all the parties to the suit, then the court will formulate the terms of the settlement, and the court may also reformulate the terms of settlement and referring the same for arbitration, conciliation, judicial settlement through the settlement from Lok Adalat settlements, and mediation. Subsection 2 Where a dispute has been referred to first A for arbitration or conciliation, then the provisions of the Arbitration and Conciliation Act 1996 shall apply, as if the proceedings for the arbitration and conciliation were referred for settlement under the provisions of this act of that act. B. To Lok Adalat, the court shall refer the same to the Lok Adalat in accordance with the provisions of subsection 1 of section 20. When the court refer the dispute to Lok Adalat, then the court shall refer the same to the Lok Adalat in accordance with the provisions of section 20 subsection 1 of the Legal Services Authority Act 1987, and all other provisions of that act shall apply in respect of the disputes which is referred to the Lok Adalat. Subsection C. For judicial settlement, the court shall refer the same to the suitable institute of a institution or person, and shall institute a person which is deemed to be the Lok Adalat. The judicial settlement, then the court will refer to the suitable institution or a person who shall be deemed to be Lok Adalat, and all the provisions of the Legal Services Authority Act 1987 shall apply, as if the dispute were referred to a Lok Adalat under the provisions of that act. D. For mediation, the court shall effect the compromise between the parties and shall follow such procedure which is prescribed. The analysis of section 89. Analysis of section 89 is that when the court is of the opinion that an element of settlement still exists which is acceptable to the parties, the court will formulate the terms of settlement and refer it for A. Arbitration and conciliation. Then the provisions of Arbitration and Conciliation Act 1996 shall apply, as if the proceedings for arbitration or conciliation were referred for settlement under the provisions of that act. When the court refers the settlement to judicial settlement including Lok Adalat settlement, then the court shall refer the same to Lok Adalat in accordance with subsection 1 of section 20 of the Legal Services Authority Act 1987 under the provisions of this act. When the court refer the settlement to Lok Adalat, then then it will the provisions of section 20 subsection 1 relating to Legal Services Authority Act 1987 shall apply to that institution or person who is deemed to be the Lok Adalat. D. For mediation, the court shall effect a compromise between the parties, shall follow